I want to welcome everyone here. I'm Gloria Palmer, the Executive Director of Green Mountain Academy for Lifelong Learning. Thank you for joining us. Today's presenter is Vincent Bonventre. He joined the Albany Law School faculty in 1990, where he is the Justice Robert H. Jackson Distinguished Professor of Law. He teaches, comments, and advises on courts, judges, and various areas of public law. He is the author of New York Court Watcher, a blog devoted to research and commentary on the U.S. Supreme Court and the New York Court of Appeals. He is also the founder and editor of State Constitutional Commentary, an annual publication of the Albany Law Review devoted to American state constitutional law. And he is the founder and director of the Center for Judicial Process. It's very nice to have you back with us, Vincent.
God, it's always great to be with you. Always great to be with this group. My favorite group. Just love being here. And I love talking about the topic for today's program. One of the reasons I love talking about it, because one of the few things I actually know something about, but also because it's one of those subjects about which most people really have no idea. I think they really don't understand because it's counterintuitive. We spend so much time thinking about, arguing about, listening about the United States Supreme Court. The fact of the matter is that for most of us in most of our states, right, I refer to them in my class as the enlightened states, the state Supreme Courts are much, much more important for the protection of our rights and liberties than the United States Supreme Court. So, for example, everybody is talking nowadays about what the United States Supreme Court will do with a woman's right to choose. The fact of the matter is, for our states, New York and Vermont, and many other states around the country, it will make no difference to that state's citizens what the Supreme Court does, because the state Supreme Courts are already protecting a woman's right to choose. And so for Vermonters, New Yorkers, those in the state of Washington and California and Oregon, and I can go on, it will really make very little difference what the Supreme Court does, because the citizens of those states are already protected. The women will continue to have a right to choose. And that is true with regard to so many other rights and liberties. That's what we're going to be talking about today. Okay, so state Supreme Courts protecting rights and liberties despite the Supreme Court, the United States Supreme Court, or as I call it in class, the federal Supreme Court. And the reason for that is that when we speak about despite the Supreme Court, it's because, as we're all aware, the United States Supreme Court, at least since the 1970s, has grown increasingly conservative. And when I say conservative, I don't mean right or wrong. What I just mean is that the United States Supreme Court, beginning in the 1970s, has really been narrowing the protection of the United States Constitution, its protection of rights and liberties, whether that's a good thing or a bad thing. Maybe it's a good thing because it leaves that up to the states. Maybe it's a bad thing because in some of these states, those rights aren't going to be protected anyway, and the people rely on the United States Supreme Court. All right, and there's our Vermont Supreme Court, a very interesting and very assertive and aggressive Supreme Court for much of its history. This is how we're going to be talking about it. Well, this is my introduction. We'll talk about states' rights. Usually we talk about states' rights, we're talking about, a third to a half of the country resisting civil rights. We're talking about especially the Bible Belt and the southern states resisting the protection of rights and liberties for disfavored groups. Well, that's not what we're talking about in this talk. What we are talking about is actual states' rights. That is the rights of states, indeed the authority of states to protect our rights and liberties, regardless of what the federal government, meaning the federal Supreme Court, does. We really need to look at the background of the federal Constitution to understand how it happens that state Supreme Courts are allowed to and historically have protected rights and liberties, despite what the Supreme Court does. We will talk about the relationship between the Federal Bill of Rights and the states. It may sound like heresy, but the Bill of Rights does not apply to the states. Bill of Rights are protections. They're restrictions upon the federal government. And that's not an opinion, that's just a fact. We oftentimes hear about, well, this state is violating the First Amendment. Well, that really is just shorthand for saying that this state has violated a freedom of speech or the freedom of the press or the freedom of religion, but it's freedom of speech, press, or religion as found in the 14th Amendment, and it is the 14th Amendment in the federal Constitution that actually protects rights and liberties against the states. But the 14th Amendment doesn't speak in any specific terms about what rights are supposed to be protected. So by and large, that's up to the United States Supreme Court to determine what the content is of the 14th Amendment, and therefore what rights are protected under the 14th Amendment against the states. We'll look at the expansion of the Supreme Court's jurisdiction, their authority, Supreme Court's authority, specifically with regard to the Supreme Court reviewing decisions of state Supreme Courts. That's an absolutely fascinating area of the law. Right now, it probably seems terribly boring, that title, expansion of the Supreme Court jurisdiction. Hey, what the heck's that about? Believe me, it's really fascinating. And the retrenchment of rights, that is the Supreme Court, again, moving backward or narrowing the protection that the Supreme Court says the federal Constitution provides to our rights and liberties. The revitalization of state court independence. Well, once the United States Supreme Court start narrowing rights and liberties, many of the states continue to protect rights and liberties, and other states which weren't necessarily doing so previously because they just relied on the United States Supreme Court to do so, they stepped into the void. We'll take a look at that. And then generally what is happening today with regard to the protection of civil rights and liberties independently under state law by state Supreme Courts. And then finally, some concluding observations. States' rights, independent state-based decision-making. Well, being very tribal, I'm going to start with New York's High Court, or the New York Court of Appeals. We don't call it the New York Supreme Court. New York Supreme Court is actually our trial court, right? It's actually our trial court. That's just a matter of historical accident, but the judges on the trial court, the Supreme, they don't want the name changed because they like to be called justices of the New York Supreme Court. And the highest court in the state, again, by historical accident, is called the New York Court of Appeals. Historical accident or not, it happens to be one of the most influential courts in the country. Throughout much of its history, it actually has been the best court in the country, even better than the United States Supreme Court. In any event, in People versus Barber, 1943, following the United States Supreme Court's decision refusing to protect Jehovah's Witnesses, who, as you know, today and back then, were going door to door, proselytizing, right, handing out literature. Well, many municipalities around the country outlawed such solicitation. Well, some of the municipalities in New York State did so as well. The United States Supreme Court refused to protect this religious practice of the Jehovah's Witnesses and would uphold these state and municipal laws. But the New York Court of Appeals treated it differently and protected the Jehovah's Witnesses. And in doing so, the chief judge at the time, Irving Lehman, pointed out parenthetically, in other words, this isn't anything new. I'm just reminding you. We may point out that in determining the scope and effect of guarantees of fundamental rights of the individual in the Constitution of the state of New York. You know, all states have their own constitution, but the rights of individuals in the New York Constitution, this court is bound to exercise its independent judgment. It's not an option. This is what state courts are bound to do, to exercise independent judgment, and is not bound by a decision of the Supreme Court of the United States, limiting the scope of similar guarantees in the Constitution of the United States. So just because the Supreme Court held, and wrongly so, which the Supreme Court admitted a few months after People versus Barber, even though the Supreme Court held wrongfully that the federal Constitution did not protect the religious practices of the Jehovah's Witnesses, the New York Court of Appeals went ahead and said, well, under our Constitution, Jehovah's Witnesses are protected. So they are allowed to go door to door in this state. Sticking with the New York Court of Appeals, and I certainly will get to as many cases as I can with Vermont, Sharrock v. Del Buick, one of the great chief judges in the history of New York. In this case, it had to do with a violation or an alleged violation of due process. In other words, somebody's property was being taken away by an automobile mechanic because the individual was late on paying what was due to the mechanic. And the mechanic simply foreclosed on the car and then sold the car. The United States Supreme Court many times has said due process does not apply to individuals, to private individuals. Due process is only a protection against government. Not so in New York. And as Chief Judge Cook said, on innumerable occasions, this court has given our state constitution an independent construction, affording the rights and liberties of citizens of this state even more protection than may be secured under the United States Constitution. This independent finds its genesis in the long history of due process protection, and more fundamentally, in the fundamental principles of federalism. That is, in our government, we have a federal system of government, we have dual sovereignty, we have the federal government is sovereign in its spheres, and the state governments are sovereign in theirs. And I know we always hear, it's like a mantra, that, you know, the federal constitution is the supreme law of the land. We know about the supremacy clause. But all that means is that states are not permitted to violate the federal constitution. For example, they're not allowed to violate federal constitutional rights. But if they provide protection to individual rights and liberties, which the Supreme Court is not doing, then the states are not violating a federal constitutional right. They're not violating the federal constitution. They're just taking an independent approach. And that's axiomatic. That's a truism in our federal system of government. Now, I don't want it to seem as though this is just the province of states such as the New York Court of Appeals and the Vermont Supreme Court. So let's take a small tour around the country. State versus Kennedy, a very famous case coming out of Oregon Supreme Court. The Oregon court, like Vermont and like New York, is very active in being independent. This case had to do with double jeopardy and whether or not the protections the protection against double jeopardy in Oregon would be stronger than the protection the United States Supreme Court requires. And the Oregon court said a state's constitutional guarantees were meant to be and remain genuine guarantees against misuse of state government powers, truly independent of the rising and falling tides of federal case law. Look at the year, 1983. So Oregon was saying, look, the United States Supreme Court used to protect the rights of the accused an awful lot, like in the 60s, but now they're not protecting them much at all. Well, we're not going to follow the rise and the fall of the United States Supreme Court federal case law. We are going to be independent. State courts cannot abdicate their responsibility for these independent guarantees. So like the New York court, Oregon is saying, no, this is the responsibility of state courts to independently protect these rights. The Pennsylvania Supreme Court, this has to do with the exclusionary rule. As many of you may know, that if law enforcement violates constitutional rights in order to obtain evidence, so they break into somebody's home in the middle of the night without probable cause, without a warrant, and after breaking in, they find evidence of a crime, well, the exclusionary rule says you're not allowed to benefit from your unconstitutional conduct. So we're not going to allow you, the government, to use that evidence that you unconstitutionally obtained. Well, as you can imagine, as with most other things, the United States Supreme Court, beginning in the 1970s, began again to narrow the rights of the accused and began to narrow the exclusionary rule. And the Pennsylvania Supreme Court says, look, we may accord weight to federal decisions where they're logically persuasive and well-reasoned, but we are free to reject the conclusions of the United States Supreme Court. It's essential that courts in Pennsylvania undertake an independent analysis. So don't just rely on what the Supreme Court says. We're not bound by that. Godfrey v. State, Iowa Supreme Court, and I know this is a surprise to many people, but the Iowa Supreme Court, right, part of the Bible Belt, the Iowa Supreme Court has been very, very progressive in the protection of rights and liberties. In this particular case, in 2017, the Iowa court said, even though the United States Supreme Court claims that there is no equal protection based upon sexual orientation with regard to private employers, Iowa Supreme Court is saying there is such protection of equality in private employment for gays and lesbian LGBTQ persons. We do not march in lockstep with federal law. The Iowa Supreme Court has a long and storied tradition of deciding cutting-edge cases well in advance of later decisions of the Supreme Court. And here you go. Here's the Vermont Supreme Court. Jeffrey Amistoy, very, very well-known, very, very well-respected former Chief Justice of the Vermont Supreme Court, and Baker versus State. In this case, the court in 1999, so that's well ahead of the United States Supreme Court, the Vermont Supreme Court said that same-sex couples were entitled to equal protection. They were entitled to the same marital rights as opposite-sex couples. It's important to emphasize at the outset that it's the Common Benefits Clause of the Vermont Constitution we are construing, not the Equal Protection Clause of the United States Constitution, right? It is an independent authority, and it's Vermont's fundamental law. Now, it's not only courts that are saying this. The federal justices are telling us this as well. And some state courts and some law professors, I must acknowledge, don't understand this. So William Rehnquist in the United States Supreme Court, when he was rejecting, for a majority of the court, rejecting the notion that there was free speech in a shopping mall, that is, individuals who wanted to protest or wanted to speak out at a shopping mall, just as they would at a street corner in the public. California said there was free speech in a shopping mall. Well, the United States Supreme Court said, well, not under the federal Constitution. But then the court went on to say, our reasoning does not limit the authority of the state to exercise its sovereign right to adopt in its own constitution individual liberties more expansive than those conferred by the federal constitution. This is William Rehnquist. You can't get too much more conservative a justice than he was. And he's saying, look, states, you certainly have the right to protect rights and liberties much more than we are. In another case, this one dealing with the death penalty, Justice O'Connor says, look, it's elementary that states are free to provide greater protections in their criminal justice system than the federal Constitution requires. What she means really is what the United States Supreme Court says the federal Constitution requires. The Bill of Rights and the states. Bill of Rights, Congress shall make no law, right? Make no law respecting an establishment of religion or the, prohibiting the free exercise thereof, abridging the freedom of the press, infringing upon free speech, goes on and on. The Amendment 1, the First Amendment, only speaks in terms of Congress. Doesn't even speak in terms of other parts of the federal government. The president, the judges, the administrative agencies. No, it only speaks in terms of Congress. Amendment 10 says the powers that the Constitution doesn't give to the federal government and what it does not prohibit to the states are reserved to the states. So the states have all the powers that the federal government doesn't have that are not prohibited by the federal Constitution. In 1789, when the Bill of Rights was being proposed by James Madison, who had been convinced by Thomas Jefferson that there ought to be a Bill of Rights, despite the fear of many of the framers and the founders, that if we had a Bill of Rights, if we start listing some Bill of Rights, we were going to get the argument in the future, well, this right isn't mentioned in the Constitution, so people don't have this right. You hear that nonsense all the time. It is just absolutely moronic. And it's hard to believe that some of the people who are saying it, lawyers, senators, judges, justices, that they actually believe what they're saying. Well, the right to privacy isn't in the Constitution, so you can't have it. Right to choose isn't in the Constitution, so you can't have it. The right of same-sex couples to be married is not in the Constitution, so you don't have it. Okay. Right from the beginning, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others. Right off the bat. Now, that doesn't mean that there is a right to choose or a right of same-sex couples to marry, right? Or a right of privacy. But it does mean that simply because the Constitution doesn't mention it, it doesn't mean that that right does not exist. The Constitution is not a catalog of rights. Beyond that, Article 14. This was the original 14th article that was proposed by Jefferson, proposed by Madison, and he and Jefferson thought it was the most important one. No state shall infringe the right of trial by jury in criminal cases, right of conscience, nor freedom of speech or of the press. That was deleted in Congress. So Congress was making it clear that the Bill of Rights would not apply to the states. Now, why did this happen? We're all aware of the fact that the so-called anti-federalists were against the Constitution because it did not have a Bill of Rights. Well, that history, like so much of our history, was whitewashed in most of our history books when we learned it in grammar school and in high school. It wasn't so much that the anti-federalists were concerned about individual rights. Federalists were concerned about the federal government intruding upon the states, the federal government insisting on rights and protections against the states. And so even though they insisted on having a Bill of Rights, they were insisting that the Bill of Rights would not apply to the states. And so even though Madison and Jefferson wanted this Article 14th to make fundamental rights applicable to the states, those anti-federalists made sure that that was deleted. And of course, early on in the Republic, the great Chief Justice John Marshall made it clear, if it wasn't already clear, the Constitution, meaning the federal Constitution, ordained and established the United States, not for the government of the individual states. Each state has its own constitution. These amendments, the Bill of Rights, contain no expression indicating an intention to apply them to the state. This court cannot so apply them. Pretty clear. 1868, after the Civil War, that changed, or it was supposed to change. Article 4, Amendment 14, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. The sponsors of the 14th Amendment figured that this meant the Bill of Rights, nor deprive any person of life, liberty, or property without due process. Not really clear exactly what the content of liberty is here, but a state couldn't deprive it, nor could a state deny equal protection of the law. Then it goes on and it says, Congress shall have the power to enforce by appropriate legislation. But the United States Supreme Court, they were not going to be held back. A very, very conservative Supreme Court. And again, what I mean is one that wasn't that interested in protecting individual rights and liberties. In the slaughterhouse cases, right, just 5 years after the 14th Amendment, made it clear that the Supreme Court itself thought that the 14th Amendment changed nothing. The pervading purpose of the Civil War amendments, 13th, 14th, and 15th, was the freedom of the slave race. Main purpose was to establish citizenship of the Negro. The privileges and immunities, right, of the 14th Amendment are those which belong to citizens of the states, and they're left to the states for security and protection, not the federal government. In other words, we don't think the 14th Amendment changed anything. If you think that case was bad, these two cases are even worse. United States versus Cruikshank, Congress had passed a law, right, prohibiting the violation of civil rights, particularly aimed at the Ku Klux Klan. Well, after a white supremacist mob killed more than 100 African Americans in Colfax, Louisiana, the United States Supreme Court reversed the convictions and said, look, the 14th Amendment does not allow the federal government, does not allow Congress to prohibit what private individuals do within the states. And in the civil rights cases, Congress had passed what now are the civil rights laws, but back then, the first civil rights laws prohibited racial discrimination and other discrimination in common carriers and in other accommodations such as hotels, motels, et cetera, et cetera. The United States Supreme Court said, look, the 14th Amendment doesn't provide any protection against racial discrimination in transportation facilities, hotels and inns, and in theaters and places of amusement. The civil rights laws of 1875 are invalid. So the court actually back then, again, multiple times said the 14th Amendment doesn't change anything, and it doesn't give Congress any authority to prohibit discrimination. That changed to a large extent in 1937 with Justice Benjamin Cardozo, Holko versus Connecticut, immunities that are implicit in the concept of ordered liberty. Implicit in the concept of ordered liberty, one of the most famous phrases in constitutional law history, through the 14th Amendment become valid against the states. So if they're implicit in the concept of ordered liberty, they're valid against the states. A study and appreciation of the essential implications of liberty itself, in the belief that neither liberty nor justice would exist if they were sacrificed. This is true, freedom of thought and freedom of speech. So Benjamin Cardozo set forth the foundation for making the 14th Amendment actually effective in protecting those liberties, those privileges and immunities, which were essential to a free society. And that has been henceforth the jurisprudence of the United States Supreme Court in determining what rights under the federal Constitution are assertable against the states. And by a process of nationalization, we call it incorporation, free speech in the Gitlow case, free press, freedom of religion, separation of church and states, search and seizure rights. You'll notice search and seizure rights were not made applicable against the states until 1961. Cruel and unusual punishment, that prohibition, not until 62. Right to counsel, not until 1963. Right to privacy, 1963, the Griswold case, the contraceptive case. Right to marry, 1967. The right to a jury trial, 1968, those nasty 60s. That's when most of the rights in the Bill of Rights and some that aren't in the Bill of Rights became applicable to the states because the Supreme Court was saying that liberty in the 14th Amendment included all of these because, like Justice Cardozo said, these are essential to a free society. But then the United States Supreme Court, after the 1960s, the court became much more conservative and start backing up. Now, I want you to notice something. Look at these cases. Gitlow, he's going to the United States Supreme Court and saying, protect my rights. Neer, going to the United States Supreme Court, protect my rights. Cantwell, protect my rights. Everson, protect my rights. Mapp, Robinson, Gideon, Griswold, Loving, Duncan. You know, if you visit the United States Supreme Court, the guardian of our rights, people come here to seek justice, to seek the protection of their liberties. That's what was happening in all these cases. But when the United States Supreme Court became more conservative, look what happened. It's Oregon. It's the FCC. It's the state of New York. It's Illinois. It's Massachusetts, Oregon, Arizona, California, Washington, Kansas. You're probably saying, what's with these states? For example, in New York, of course, this is the executive branch. This is the New York prosecutors. In Illinois, the Illinois prosecutors. The Massachusetts, it's Massachusetts prosecutors. In all these cases, Oregon, New York, Illinois, Massachusetts, Oregon, Arizona, California, Washington, Kansas, it was one branch of a state government, the executive branch, the prosecutors, complaining that their state Supreme Courts were protecting rights too much. So Oregon was complaining that the Oregon Supreme Court protected Miranda rights too much. In New York v. Belton, the New York prosecutor was complained that the New York Court of Appeals was prohibiting too many warrantless searches. Illinois v. Gates, the Illinois prosecutor was complaining that the Illinois Supreme Court was requiring probable cause. On and on and on. These are intrastate squabbles. These are squabbles between two different branches of state governments. Who the heck ever heard that you go to the United States Supreme Court to protest that your state court is protecting rights too much? I guarantee if you go on a tour of the United States Supreme Court, they will never tell you that their purpose is to make sure that the state courts aren't protecting rights too much. They'll never tell you that. Nevertheless, 1983, the court made it clear. Respect for the independence of state courts, that's kind of a joke, have been the cornerstones of this court's refusal to decide cases where there's an adequate and independent state ground. In other words, where the state court is really protecting rights under their own constitution or under their own law. In determining whether we have jurisdiction to review the case, whether we'll even take it, we'll assume that there are no such grounds. In other words, beginning in 1983, the United States Supreme Court rendered a decision, and it said from now on, anytime a state court decides a case, we're going to presume they're doing it based upon what we, the Supreme Court of the United States, has said. We're going to presume they've decided it under the federal Constitution, unless they make it clear that they're not basing it on the federal Constitution. That way, we'll have authority to review them. Because if they were rendering the decision based on state grounds, we can't review it. We have no authority. So we're always, from now on, we're always going to presume that a state court decision is based on federal law. The dissent in that case said the final outcome of the state processes, in this case in Michigan, offended no federal interest whatsoever. Michigan simply provided greater protection to one of its citizens. You see, this is Michigan v. Long. Michigan was complaining that the Michigan Supreme Court protected Long's rights too much, right? And Stevens is saying, what the heck is the federal interest here? No federal right was violated. Michigan actually protected somebody's rights more. I am baffled by the court's suggestion that it must stretch its authority, its jurisdiction, and reverse the judgment of the Michigan Supreme Court in order to show respect for the independent courts. That's where we are. Here's the response to Michigan versus Long. New Hampshire, gotta love New Hampshire. Our citizens are entitled to an independent interpretation of the state constitution. We hereby make it clear that when this court cites federal or other state court opinions, so when we cite the Supreme Court's opinions, we're relying on those precedents merely for guidance. We do not consider our results bound by those decisions. In other words, the United States Supreme Court, leave our decisions alone. We're not relying on your decisions. We're independently deciding what the heck we should do under our own law. And we're just looking to your opinions to see whether they make any sense. South Dakota, who would have thought South Dakota in a self-recrimination case? This case is before the court on remand. In other words, the United States Supreme Court had reversed the South Dakota Supreme Court. The Supreme Court's decision is not controlling. We alone determine the extent of protection afforded under our state constitution. So take that, the Supreme Court, right? You reversed us, but we're telling you right now, we'll do what we want under our own constitution, and we're going to protect the self-incrimination rights of our citizens. Vermont, Thomas Hayes. This is the best picture I can get of this guy. For some reason, Vermonters don't like to take a color picture of this guy. I could not find another picture of him. Justice Hayes. This was an automobile stop and arrest case. To protect his and her client, it's the duty of the advocate, of the lawyer, to raise state constitutional issues. Don't be relying on the Supreme Court's opinions. It's the corresponding obligation of the Vermont Supreme Court to address the state constitution. If we breach this duty, we fail to live up to our oath. The parties in this case are hereby directed to prepare and file supplemental briefs addressing the state constitutional issue. In other words, go back and do your homework and talk to us about the Vermont Constitution. Talk to us about Vermont fundamental rights. Don't be coming up here and arguing to us what the Supreme Court did. People versus Class, the New York Court of Appeals. Supreme Court stated that our decision did not rest on an adequate and independent state ground. In other words, the United States Supreme Court, again, took a Court of Appeals decision and reversed it and said, well, we're presuming that you base your decision on our decision. And Chief Judge Kaye says, at this juncture, we cannot disregard the fact that we held that our state constitution was violated. We have already held that the state constitution has been violated. We should not reach a different result just because the Supreme Court disagrees. Independent civil liberties. Civil liberties. State v. Hirschberger, right? The Minnesota Supreme Court. Some of you may be familiar with Oregon versus Smith. I actually gave a lecture to this group about it. Now, in 1990 decision, it's one of the disasters of Antonin Scalia, in which he diluted the protection for free exercise of religion. So free exercise of religion under the federal constitution is the least protected federal constitutional right. In every other federal constitutional right, if that right is abridged, if it's infringed, there's what's called strict scrutiny. The government must justify its infringement. The government must show it has an overriding interest. And number two, it can't promote that overriding interest any other way than to abridge the fundamental right. But Antonin Scalia lied, and he said, oh, we never said that for freedom of religion. Yeah, as though freedom of religion is just the first clause of the First Amendment, is somehow lesser than other rights. And he said, no, as long as the law is otherwise legitimate, it's otherwise valid, it beats free exercise of religion. Well, the Supreme Court said the Supreme Court's holding, in other words, Scalia's opinion, does away with the traditional compelling state interest test. In other words, the government must really justify it's got a necessary, important interest. The Minnesota Constitution provides an independent basis. Only the government's interest in peace or safety or against acts of licentiousness will excuse an imposition on a religious freedom under Minnesota. So we don't care what you did, United States Supreme Court, we're protecting free exercise of religion. The Oklahoma Supreme Court, who would have guessed? The United States Supreme Court said, yeah, the Texas 10 Commandments monument, that doesn't violate the separation of church and state. They actually said something ridiculous like, oh, the 10 Commandments is secular. Okay. They do that a lot, the United States Supreme Court, when they want to allow a government to have some kind of a religious scene or religious monument. They'll say, oh, it's just secular. They also did that with the nativity scene. So you have the baby Jesus, you got the Blessed Virgin Mary, you got St. Joseph, and the Supreme Court actually has the goal to say, well, that's become secular. Yeah, all right. Well, the Oklahoma court said, the issue in the case at hand is whether the Oklahoma 10 Commandments monument violates the Oklahoma Constitution. The 10 Commandments are obviously religious in nature. So the Oklahoma Supreme Court said, well, we don't agree with the Supreme Court of the United States. You can't put up the 10 Commandments in an Oklahoma public building. State v. Henry, Oregon, free speech had to do with obscenity. The Oregon Constitution, independent of any First Amendment analysis. The United States Supreme Court does not protect obscenity. The United States Supreme Court said that even though the First Amendment says there shall be no law abridging freedom of speech, the United States Supreme Court has carved out certain exceptions. So in other words, no law abridging freedom of speech, but all those great textualists out there, they have construed no law abridging free speech to mean no law abridging free speech, except for some speech we don't like. So obscene speech, meaning vulgar sexual speech, right? Obscene speech, writing, or equivalent forms of communication are speech. Under the Oregon Constitution, any person can write, print, read, say, show, or sell anything. So the Casey case, the court says, it offers no real guidance. This court finds no justification for exchanging the long-established constitutional doctrine of strict scrutiny. Remember, really, really important government interest, and the government can't fulfill that interest any other way. We don't understand why the Supreme Court's exchanging that test for undue burden, applicable simply to the right to choose. So we're going to protect the right to choose, regardless of what the Supreme Court does. The Ohio Supreme Court. This court has previously likened the termination of parental rights to the death penalty, right? We hold that when the state seeks to terminate a parent's parental rights, the parent has the right to counsel. So Ohio, even though the Supreme Court rejected this, Ohio extends the right to counsel to cases involving the possible termination of parental rights. Partisan gerrymandering. You may all remember that a couple of years ago, the United States Supreme Court refused to invalidate extremely partisan gerrymandering, cracking and packing and making sure that the politicians in power would remain in power. So for example, in North Carolina, even though the Democrats win a majority of the vote, overwhelmingly the legislature is in Republican hands because of the gerrymandering. The Supreme Court says we can't do anything about it. Well, the North Carolina court said elections are not free, where the partisan will of the mapmaker predominates. Systematically entrenching a political party is what the North Carolina Constitution forbids. Extreme partisan gerrymanders violate the fundamental constitutional rights of free elections, equal protection, speech, assembly, and association. It's this court's duty to say so, even though the Supreme Court refuses to. What about the rights of the accused? People versus Scott. The Supreme Court has this view that, and one of them is open fields, that if anybody else, any private person, might have access to somebody's property, to somebody's information, so private person. So for example, open field. You know, you got kids there running across your property to get to the school bus. Or you have some neighbors, you know, crossing your property as a shortcut, right? The Supreme Court says, if any private person is doing this, can do this, well, then you have no legitimate reason to think that the cops can't do this, searching for criminal evidence. Well, of course, that doesn't follow at all, right? So the New York Court of Appeals and the Vermont Supreme Court has ruled the same thing. The Supreme Court's so-called open fields ruling, they make it sound as though we're talking about a ranch in Wyoming. All it means is anything outside the curtilage. The curtilage just means the area immediately adjacent to your home. So the area within peeping distance of your home. But beyond the peeping distance, beyond the curtilage, the Supreme Court says that the Fourth Amendment does not protect it. Because, among other things, the Supreme Court says, well, the Fourth Amendment only says persons, houses, papers, and effects. It says houses. It doesn't say your private property. It just says houses. Well, that may seem to you ridiculous. It certainly does to me. But in any event, courts like New York and Vermont have rejected that doctrine. And the New York court said the rule that an owner can never have an expectation of privacy in open lands, meaning anything beyond the curtilage, the unbridled license given to agents of the state to roam at will without permission on private property in search of incriminating evidence is repugnant. So the Supreme Court says you don't need probable cause. The police don't need a warrant. They can go on your backyard if it's big enough, let alone on your private property if you own a farm or a ranch, because you don't have any reason to expect privacy. And in any event, the Fourth Amendment only protects houses, not your private property. State v. Morris, love this one, love this one. The United States Supreme Court in the Greenwood case said, look, when you put the garbage out on your driveway, right? So you got it in an opaque bag. It's a black bag, you know, and you tie it up, and then you put it in your trash can. You put the cover on the trash can. The United States Supreme Court had the gall to say that the police don't need a warrant. They don't need probable cause. They don't need any justification whatsoever to take the lid off your garbage can, to take your bag out, to rip the bag, and to rummage through your garbage and everything that's in your garbage. Because everybody knows, literally, the court said, the Fourth Amendment does not constrain police from warrantless searches because dogs, raccoons, children, scavengers, and snoops can always get into your trash bags. So you know darn well that dogs, raccoons, they also said hobos, right, can get into your trash. So you have no reason to think the cops aren't going to do it. Well, the Vermont said, look, an individual's trash often reveals intimate details, right? Confidential matters. One may accept the possibility that one's garbage is susceptible to invasion by raccoons, and yet reasonably expect that the government will not systematically examine one's trash bags in the search of criminal conduct. I love teaching that case. Here's another one from Vermont. This had to do with aerial surveillance, another ridiculous thing. The United States Supreme Court has repeatedly held, look, we all know that there are commercial air flights. We all know, for example, there's a medevac. So a helicopter, private helicopter, may fly over your backyard. Well, since we know American Airlines may fly over your backyard, or that the medevac may fly over your backyard, you have no legitimate reason to think that the cops won't be flying over your backyard in search of criminal evidence without a warrant. So in this particular case, Florida v. Riley, the police in a helicopter were literally hovering over somebody's backyard. And the Supreme Court said, well, they don't need a warrant, and they don't need probable cause. You have no reason to expect privacy. Well, the Vermont Supreme Court said, the United States Supreme Court has decided that aerial surveillance is not even a search. They say it's not even a search because you don't have no reason to expect privacy. However, it simply does not follow that whether a member of the public, like Southwest Airlines, American Airlines, and Medevac, is in the public airspace is an adequate test of whether government surveillance from the same spot is constitutional. So that's not allowed in Vermont. State v. Thompson. The United States Supreme Court also has this doctrine, as I told you, if anybody else has access to this information, the police can get it without probable cause and without a warrant, all right? So in the Smith case, the United States Supreme Court said, look, since telephone companies, right, they know, they have a record of who you're calling, they have a record of who's calling you, you have no right to expect that the police can't get that information, right, and use that information against you. Well, of course, that doesn't follow at all, right? And even Vermont said so. In Idaho, there's a legitimate and reasonable expectation of privacy in phone numbers, right? So it's simply not enough to say that there's no legitimate expectation of privacy because the caller assumes the risk that the telephone company will disclose them to the police. This is not because such a list could reveal identities of the person and places called, and thus reveal the most intimate details of a person's life. State decline. Iowa, once again. The United States Supreme Court has this good faith doctrine. If the police didn't know that they were violating your rights, the evidence that's obtained unconstitutionally can still be used, right? Iowa, like every other enlightened state Supreme Court, has totally rejected that, saying that all this does is encourage police ignorance. Oh, there's another one, the exclusionary rule. Unconstitutionally obtained evidence. The Supreme Court has said, well, that evidence may still be used in any civil proceeding, deportation proceedings, revocation of probation, tax proceedings, deportation proceedings, anything else. And the Supreme Court says, yeah, it doesn't apply. Well, the Vermont Supreme Court said, no way, we're not allowing this evidence to be used in civil proceedings either. Because what'll happen is the police know it's a win-win situation. You might as well violate somebody's constitutional rights because you could still use the evidence as a civil case. In this particular case, it had to do with the suspension or the revocation of a driver's license. The police unlawfully stopped somebody, and so the evidence could not be used in the criminal case. Even the Supreme Court agrees with that. But Vermont says we're not going to allow it to be used in the civil enforcement proceedings either, because otherwise the government is benefiting from its unconstitutional conduct. State v. Bayard. This case from the United States Supreme Court is an absolute outrage. In the Atwater case and the Florence case, the United States Supreme Court held that regardless of how minor an offense, in Atwater, it was a seatbelt violation. In Florence, it was an unpaid traffic ticket, which, by the way, had already been paid, but the police didn't know, so good faith exception, right? So traffic ticket not paid, seatbelt violation. The Supreme Court said it's still fine, not just to give the person a ticket, but to arrest the person, search the person, bring the person back down to the precinct, strip search the person, and then hold the person in a jail cell while processing the ticket. Totally outrageous. Well, many courts, including the Nevada court, said, no way. Absent special circumstances requiring an actual arrest, individuals should not be made to endure the humiliation of arrest and detention when a simple citation, a ticket, will satisfy the state's interest. New York, that's been the law for a long time. Let me go ahead to the end. I wanted just a few concluding things. Again, Vermont there he is again, Justice Hayes. He actually was only on the Vermont court for a few years, and then he died of lung cancer. But that case, State v. Jewett, and he puts the blame right where it ought to be. The fact that law clerks working for state judges, including those of the Vermont Supreme Court, apparently, have only been taught or are familiar with federal cases, meaning United States Supreme Court cases, brings a federal bias to the various states. The lack of treatises or textbooks, developing the rich diversity of state constitutional law developments, which we've been talking about, right? Could be viewed as an attempt to nationalize the law and denigrate the state bench, despite the burgeoning developments in state constitutional law. Only about a dozen law schools have courses in state constitutional jurisprudence. So he's complaining about legal education, and rightfully so. Massachusetts v. Upton. This is a case, okay, Massachusetts v. Upton. So you know what? It's Massachusetts prosecution complaining about the Massachusetts Supreme Judicial Court for protecting somebody's rights too much. The Supreme Court took the case. Oh, we're going to take the case because we presume they based their decision on the federal Constitution. Stevens says the judgment of the Supreme Judicial Court rested its decision on the United States Constitution. That reflects a misconception of our constitutional heritage and the respective jurisdictions of state and federal courts. The court, meaning the Massachusetts court, disparaged the rights retained by the people of Massachusetts under the Massachusetts Constitution. The states in our federal system remain the primary guardian of the liberty of the people from abuse by state authorities. The Massachusetts court ignored this fundamental premise of our constitutional system. And then Chief Justice Berger, in his report on the judiciary in 1981, state courts are responsible for first resolving issues arising under their constitutions and statutes, and only then for passing on matters concerning federal law. And yet law schools, law professors, lawyers, many state judges just simply don't get it. And finally, Chief Judge Kay in New York, this was the Open Fields decision rejecting the Supreme Court, a state court decision that rejects Supreme Court precedent and opts for greater safeguards as a matter of state law, does indeed establish higher constitutional standards locally. But that is a perfectly respectable and legitimate thing to do. Can you imagine? It's 1986. She had to explain to some of her colleagues that this is a perfectly respectable and legitimate thing to do. In those instances where we have gone beyond the Supreme Court interpretations of federal constitutional requirements, our objective has been the protection of fundamental rights consistent with our Constitution, with our precedents, and our own best human judgment. And just think of the current Supreme Court and how vital it is for state courts to step up and to do their duty and to independently construe their state constitutions instead of simply relying on the United States Supreme Court decision. And that's it. So I'm open to your question.
But the last slide that you showed of the US Supreme Court, you had Amy Coney Barrett in a larger picture. Is she the most conservative then?
No. The reason I had her in a larger picture is because I also had the picture of Ruth Bader Ginsburg faded out. And Amy Coney Barrett replacing her.
Yes, okay.
The difference that was making. That's the only, so let me go back to that. We went from one of the most liberal justices on the court, Ruth Bader Ginsburg, together with Sonia Sotomayor, to one of the more conservative members of the court. That obviously changes pretty drastically the direction of the United States Supreme Court. We've been talking about Chief Justice Roberts being a moderating influence on the court, being the swing vote, but his vote doesn't even count anymore. because even if he joins the Liberals, there are still only 4 now: Sotomayor, Breyer, Kagan, and Roberts. And we've seen that in many cases already. And then you still have the majority, the 5 more conservative members of the court. So, you know, the court is definitely going to swing even more conservative than it has been. And it's been pretty darn conservative.
Rosalie, I saw your hand up.
Oh.
Unmute yourself.
And I don't know if my question is totally in line with your presentation, but
That's
maybe
okay.
you could explain it. I understand that there's a process that's been underway for a while for the states to pass I don't know if it's a resolution, I think it might be called the Wolf Pact in Vermont, where the states would allow, if a certain number of states say that they want to have a constitutional convention, that they can all get together and they can amend the US Constitution. So I'm not quite clear. If you can explain that, I don't quite understand how far that could take us.
Sure. Well, that's right in the federal constitution. If 3/4 of the states want to have a federal constitutional convention to amend the Constitution, they're allowed to do so. That's one of the ways in which you can amend the federal Constitution. So even if Congress doesn't take the step forward, the states can. That's what that's all about. Now, I'm not particularly familiar with the proposal you're speaking about. Is that to amend the Constitution for what reason?
Well, that's what I'm wondering, because all of the folks on the left are saying it would be a free-for-all for the conservatives to come in and try to pass something. So if there's something that the liberals want to see added to the US Constitution, we put ourselves at peril as liberals, and that's what I am.
Yeah.
To find that the conservatives want to just go ahead and do something. So I believe, I don't know if we can rescind, some of the states can rescind their approval to hold such a convention unless there's some compelling reason to do so.
Well, I would be shocked if there ever were 3/4 of the states that voted to have a federal constitution for exactly the reasons you stated. Several of the states, for example, have tried to have state constitutional conventions. In New York, there was a movement to have one a couple of years ago, and it was rejected quite soundly. And it actually was some liberals that were pushing to have a state constitutional convention. But it turned out that ultimately the liberals were overwhelmingly against it because they were afraid what might happen if you had a state constitutional convention. They were afraid what might happen to the state constitution. For example, you could imagine a state constitutional convention in which you had more conservative state senators proposing an amendment and getting it passed that the New York Court of Appeals had to follow the United States Supreme Court. That happened in Florida. You know, the Florida Supreme Court is required to follow whatever the United States Supreme Court happens to say. When the Florida Supreme Court is faced with a question under its own law, they're required to follow the United States Supreme Court. So literally, the people of Florida have abdicated the independence of Florida as a state, right, to the United States Supreme Court. So what does the Florida Constitution mean? It means whatever the United States Supreme Court says the federal Constitution means. How does that grab you? Well, people are afraid. A lot of liberals are afraid if there are state constitutional conventions, conservatives, the Republicans, may get control and may end up being able to enact such a provision. Yeah.
I don't know if you're aware that one of the big examples was not just the same-sex in Vermont decision, but the financing of our schools.
Yeah.
It was overturned based on the state constitution that had a right to an equal education.
That's so great.
That didn't really exist in the federal constitution. And we have a little nicety in Vermont in that the state constitution existed for 10 years before we were a state.
Yeah.
When we were an independent republic, there's a little body of law.
Right.
And when I was, I think I'm the only Vermont attorney here, but when I was brought into when I was admitted to the bar, there used to be a ceremony where you had tea with the justices so they could take your measure. And one of those justices was Tom Hayes.
Yeah.
When I was admitted, which is a while back.
Yeah. That's a great point. And Gloria would have reprimanded me if I went over an hour. So I had to limit it. But that's absolutely a great example. You know, the United States Supreme Court, in a case, San Antonio versus Rodriguez, said that, get this, in the United States, supposedly a democracy, right? Intellectually founded by such as Thomas Jefferson, right? The United States Supreme Court said that education is not a fundamental right. And they said that, oh, we're leaving that up to the states. Okay, so what has happened? Well, you know what's happened in the usual suspect states. All they do is they just repeat what the Supreme Court has said. They said, well, under our own Constitution, education is not a fundamental right. Okay, yeah, all right. Even though actually Justice Lewis Powell, who was one of the greats, he made it clear. He said, one of the reasons we're doing this is because we want to leave it up to the states independently to take care of education. So what do most of the state courts do? They say, well, the Supreme Court said it's not a fundamental constitutional right, so we're following that. No, the Supreme Court said it's not a fundamental constitutional right under the federal Constitution because they were leaving it to the states. Vermont was one of the first states to say, we're taking an independent approach. Well, of course, education is absolutely fundamental to a democracy. And therefore, we want to ensure equality in the funding of education, regardless of whether the school district happens to be a wealthy one or a poorer one. But many of the state courts are absolutely struggling with that. In New York, for example, New York, New Jersey, and several other states, they will tell the legislature, look, you have to fund school districts equally, at least so that no matter what school district the child is in, the child gets a good education. There's enough money. And then the legislature
just so you know that we're not that holy, the state education tax is shipped up to Montpelier. And Governor Douglas, a Republican governor, said that it could be used to finance the pension of the teachers, which doesn't get any more education to anybody.
Right.
And Governor Dean, Howard Dean, a Democrat, used some of it to financing a parking garage in Williston.
Yeah.
So it's more like Willie Sutton. Why do you know? That's where the money is. Neither side is going to get rid of it.
Oh yeah.
But it was a big case that they used the state constitution. So.
Oh yeah, yeah. No, Vermont has been out in front with lots of things. And what many of the states have done, even after their state Supreme Courts have ordered equality with regard to education funding, what they've done is similar to what the federal government has done. And it wasn't just Reagan, also liberal presidents. What they've done is they've invaded the Social Security Trust Fund, and they've used that to supposedly balance budgets, right? And those of us who are collecting Social Security, right, of course, we're very concerned about that. They're talking about Social Security's bankrupt. Yeah, of course it's bankrupt because you're using Social Security Trust Fund to fund so many other things.
What is the possibility of the Supreme Court reversing state court decisions on all of these new election laws that have been passed in the last 12 months or thereabouts? Because in states, in state courts, they're going to demand their right to do it. And the Supreme Court
what might happen is that if decisions to protect voting rights are made by state Supreme Courts. What the Supreme Court could do, and what several justices have voted on in previous cases, what they will say is that the federal Constitution leaves election laws up to the state legislature. And therefore, if the state legislature restricts voting rights, the state Supreme Courts can't do anything about that. So if the state Supreme Courts are saying, no, voting rights, elections have to be held a certain way to protect people's free speech and their voting rights, several justices of the court have already said they think that's unconstitutional. They already have said that those determinations are up to state legislatures and the state Supreme Courts cannot interfere. Now, the other thing is, if the state legislature actually expands voting rights and restricts what the political parties can do, right? The Supreme Court can also say that, no, what you are doing is you are interfering with a private political party and the way a private political party wants to handle its elections. You know, look, you've got about 3, maybe 4 on the United States Supreme Court. I wouldn't put any of that past them to overrule any of the state, whether it's legislative or judicial intentions on protecting the right to vote. You know, yeah, we're going to see plenty of cases like that. You know, we have cases, for example, we had one a few years ago where Arizona was one of those states that created an independent commission to do gerrymandering, an independent commission. Because, you know, right now, I mean, it's just an abomination what happens with gerrymandering. Arizona created an independent commission, and the independent commission is the one that carves up the districts in a state. There were 4 votes. There were 4 votes at the United States Supreme Court saying that Arizona could not do that. Could not do that. That was several years ago, and the court has changed. The court has changed. Some of those liberals are gone. Some of the liberals are gone now. So, you know, that could change now. They could say, the current justices could say, that was a wrong decision, just like we think Roe was a wrongly decided case, just like we think Casey was a wrongly decided case. We think the Arizona case was also wrongly decided. And that's up to the legislature to carve out legislative districts, voting districts. It's not up to an independent commission. The federal Constitution doesn't allow that. I wouldn't be surprised if you get a reversal of the precedent on that basis.
2 questions. Number 1, does a private individual have a right standing to bring a voter suppression case?
Only if the private individual can show that the private individual's voting rights were actually hampered. It can't simply be, for example, that, well, I think that voting rights generally are going to be hampered. That won't be enough. The reason for that is, for those of you who are not lawyers, the United States Supreme Court has this standing doctrine that you must have been personally injured in order to bring a case in federal court. What the Supreme Court, the current court, again, which is much conservative, which means that unless you're talking about gun rights, or unless you're talking about complaining about affirmative action, the United States, this current court is really limiting standing. And it will often say, if you're complaining about something that lots of other people in the citizenry can complain about, you're just bringing a general complaint. You're not personally injured. You just don't happen to like something that the legislature passed or your court has decided, but you don't have any more grievance than any other general member of the public. The Supreme Court has been deciding cases like that repeatedly over the last several years to limit the extent to which individuals can complain about restrictions of individual rights and liberties.
Okay,
And the environment, same thing. Go ahead.
Okay, thank you. That was good. Now, if you could just explain a new phrase that's making the rounds these days, which is voter subversion. What is that?
Well, in fact, I think I just heard it. I think I just heard it today.
Yeah, right. Me too.
Voter subversion. And I'm not sure what that is, what the difference is. Maybe that's just a variety of voter suppression. I don't know. I mean, do they mean that there are people voting that shouldn't be voting? Are they talking about votes somehow? Oh, I do know what it means. It just clicked. Voter subversion has to do with, several of these states are passing election laws in which those who monitor the votes and count the votes are actually political activists, right? They're very partisan. Well, voter subversion is that somebody votes, right? Say a Democrat votes, right? And yet there are partisan Republicans who are deciding whether or not those votes count. So, for example, Trump complains that, the Georgia election was tainted. There were all these fake votes. And now, for example, maybe you have very partisan Republicans. Instead of a bipartisan panel, you have very partisan Republicans. They're the ones who are now counting. And so they're the ones who might take a skewed look at some of these votes and undermine, subvert these votes, which otherwise would be counted. That's what they're talking about. I know Biden was complaining about that today.
Okay, thank you. Thank you.
Ed Morrow.
Thank you. Could you discuss a bit more the possible conflicts that would exist between state Supreme Courts and the federal Supreme Court in possibly upcoming voting rights rulings? You gave ample illustration of where the state Supreme Court says, well, it's nice you decide that way, federal court, but we don't care. We're going our way.
That's right.
So why can't they do that? And what would happen in the conflict between courts?
Absolutely. Say, for example, which is one of the states that's passing these, Georgia, right? Georgia. So Georgia says, people are waiting online to vote for 3 hours and you're not allowed to give them a bottle of water. Okay. So say the case that's challenged, the United States Supreme Court almost certainly is going to uphold that. It gets to the Georgia Supreme Court. Maybe the Georgia Supreme Court will say, look, under our own Constitution, we think it's perfectly fine. We think it's perfectly fine if somebody wants to give somebody online a bottle of water. And we don't think there's any legitimate reason for the Georgia legislature to have prohibited giving somebody online a bottle of water. So it's too bad what the United States Supreme Court has ruled upholding that prohibition. We are holding that prohibition is completely arbitrary and it's a violation of our own Constitution. So what would happen is that giving somebody, a voter who's in line, a bottle of water and a state prohibiting that would be fine under the federal Constitution. But that doesn't stop Vermont, New York, or any other state Supreme Court for saying, there's no legitimate reason for prohibiting that. So we're going to allow, you want to give somebody who's about to vote, you want to give them a bottle of water, you can go ahead and give them a bottle of water in our state. It's not, see, that's not really a conflict. Because all the Supreme Court, the only authority the Supreme Court has is to say whether or not the state is doing offends the federal Constitution or it doesn't. So if a state says you can't give water to a voter online, and the Supreme Court says that's fine, all they're saying is that doesn't offend the federal Constitution. It can offend the Georgia Constitution, and that's not a conflict.
What that's in a fairly benign case, maybe not so benign, but what I'm really asking about then is, suppose the executive of Georgia says, well, Georgia Supreme Court, you're wrong in this case. We believe the federal Supreme Court, and we're going to enforce what the federal Supreme Court says, not what our Supreme Court says. Could that happen?
Well, that executive would be in violation of the fundamental law of Georgia and could be held in contempt. Yeah, I mean, he would be breaking the law. He would be breaking the law. Look, I spoke about, for example, the open fields doctrine, which Vermont has rejected. The United States Supreme Court says, as long as the police stay away from peeping distance, the curtilage, right? They're allowed to go on your property, no probable cause, no reasonable suspicion, no warrant. They're allowed to go on your property. So you go out in the morning and you see all these cops with the cop cars and everything searching the far end of your backyard. Say, what the heck is going on? You got a warrant? No. You got any reason to be doing this? No, the Supreme Court says we don't need it. But wait a minute. The Vermont Supreme Court says you do need it, right? So then you bring a case to the lower court, and the lower court will tell the cops they're not allowed to do this. And that evidence is suppressed. Any evidence they obtain is suppressed. And the courts will order the police department, you're not allowed to do this anymore under Vermont law. That's what, again, there's not a conflict, because all the Supreme Court is saying is that when the cops do this without a warrant, without probable cause, they're on your private property beyond the house, right? We don't care. The federal Constitution is not offended. When Vermont says, well, the Vermont Constitution is offended, you're not allowed to do this in Vermont, right? That's not a conflict. That's not a conflict. And the cops in Vermont are going to have to obey that.
But okay, I'll pursue it a bit further, if I may.
Sure.
You just gave an example where the state court, where the state court's not violated, or the state constitution is violated.
Right.
But in the case of voting, restrictions, I'm getting myself in too deep here. The case, if there's nothing in the Georgia Constitution, and it's just a matter of the two courts differing on how they interpret, what's to prevent the executive from saying I'm going ahead because it's not clear, but the federal Supreme Court says it overrules what you're saying, state court.
Except that the supreme law of that state is what that state court has said. Now, we oftentimes, right, have conflicts between what the executive branch wants to do and what the judiciary is saying they must do or must not do, right? You have this in the federal system, you have it in state systems. But if the executive, if the governor is insisting on doing something, right, which the state Supreme Court says you can't do, well, the governor is violating the law of the state. There's no question about it. And the fact that the Constitution doesn't happen specifically to say you have a right to give somebody in a voting line a bottle of water, I mean, that doesn't mean anything, except for these idiots that keep saying, well, it's not mentioned in the Constitution. Constitutions are not catalogs of rights. We keep talking about them that way because those are the kinds of cases that are the sexiest, right? The individual rights and liberties cases. But constitutions are frameworks for how a government works. In all of our states, just like in our federal government, what the Constitution protects, right? the liberty, the rights, the privileges that it protects, we leave that up to courts, right? That's judicial review. It didn't have to be that way, but that's what we have adopted in this country. We adopted that in colonial times, that the courts have the final word on what fundamental rights are, right? So that's been the rule, the law of governance in the United States for almost 3 centuries now, really, almost 3 centuries, because it went even before the federal Constitution. So judicial review, the state courts, high courts, or the federal Supreme Court, they have the final word on fundamental rights and liberties. And if a chief executive, whether it's the president or whether it's a governor, right, disregards that, the president or the governor is violating the fundamental law of that jurisdiction.
But it may not make a difference. The governor may just choose to violate the law and say, I don't care about that. And who's going to stop him?
Yeah, I mean, the famous story, which might be apocryphal, that President Andrew Jackson, in the Supreme Court ruled against Jackson's interest and in favor of the Indians at the time. Jackson said, well, the Supreme Court has rendered its decision. Now let them enforce it. I'm not going to obey it. Right. So, I mean, there's not much a court can do. Right. The court doesn't have the sword. Court doesn't have an army. And if the chief executive, wishes to violate, right, the fundamental law coming out of a state Supreme Court or coming out of the federal United States Supreme Court, there's not much the court itself can do.
Thank you, Vince, for being here. And thank you all for joining us. And we hope to see you at the next lecture. Have a good night.